As you know, here in North Carolina, we are the state's premier free market think tank looking at freedom and trying to expand freedom, and we feel very good about the trajectory that our state is taking on a number of issues. And we feel very proud that many of our ideas that we've been talking about and writing about for years have been adopted over the last several years. When you're in the freedom movement, one of the things that you're concerned about, of course, is property rights. And over the years, we have written and analyzed many components of that issue here at the Locke Foundation. In fact, at Carolina Journal, for several years, we followed a story that we kind of shortcut and call the Hammocks Beach story, culminating in this particular issue of Carolina Journal from June of 2015, in which our own Don Carrington, who did the reporting on this, reported on the fact that finally the heirs in this case were able to reach an agreement and get their rightly and just a settlement from the state of North Carolina. Well, the interesting thing is that Ruth's firm, the Francis Law Firm, represented the heirs in this case. And today we're delighted to tell you that she's going to join us to talk about some of the things that went on in that case and the issues that really concerned her clients and her firm. Now, as we said, you may know her from her background as a reporter and columnist for the Raleigh News and Observer. She happened to be a columnist for the NNO. At the same time, my husband was there, so we got to know Ruth not only as a peer, but as a friend as well. And I'm delighted to be able to introduce her to you. Now with the Francis Law Firm, she specializes in a number of areas: personal injury, wrongful death, employment law, and now she has actually taken a keen interest in eminent domain, representing landowners whose land is being taken or condemned for public use. She tells us that she believes that every property owner should be represented to ensure that he or she is properly compensated and to protect his or her rights in the years and decades ahead. Now, of course, this is really in line with our beliefs about freedom and the importance of property rights here in North Carolina. That's why we asked her to come today to talk to you a bit about what happened with the Hammocks Beach property rights case. With that, I give you Ruth Sheehan.
Good afternoon. When I told my oldest son that I was coming to speak to you all, he said, "Do they know about you, though?" I said, "Yeah, I think they do." Probably more than most. I'm really delighted to be here. I think that this is one of those truly rare issues, property rights, that in a very fractious time in our politics, actually can unite people. Because I know I saw Justice Newby not long ago at a CLE, a continuing legal education event, and we chatted afterward because he had one of the important decisions in this long, complicated case, and we were discussing the fact that there is one thing that we can all agree on, which is that property owners, if the government's going to take our property or use our property, there needs to be just compensation. That's so elemental to our beliefs as Americans that it's in our state constitutions and in the U.S. Constitution. So this has been this is a remarkable case. I have to tell you that I was in law school for a big chunk of this, so Mr. Francis did a lot of this work, and I did not. I came in at the tail end, but he's entrusted me to tell you the tale of this. To give you a little bit of background about this case, so it started out really almost as a wills and trusts kind of case, an inheritance, and only later it became a government taking, or an attempted government taking, a rather shocking one, as Don ably wrote. The background on this thing is the Hammocks Beach property is this gorgeous land right near Swansboro. There's a park there that's basically these little out islands and just enough land at the coast for people to get in boats and get over to the out islands. This land was purchased by a neurosurgeon back in the 1920s. His name was William Sharp. He was from New York City. He began coming down to North Carolina to the coast in 1914 and quickly became friends with and started using the services of a fishing and hunting guide named John Hurst. That's Mr. Hurst right there with his hunting dogs. And he was viewed as one of the most fabulous hunting guides and fishing guides, and he could fix anything, do anything, although he was unable to read and write himself. He and Mr. Sharp became quite close, and Mr. Sharp trusted him and asked him to identify for him some land to purchase. And over the course of several years, he purchased about 800 or 900 acres right along the North Carolina coast near Swansboro to have as, he'd always gone to a fishing club, but he wanted to have his own property. This is the fishing club he used to go to, fishing and hunting club. There's Dr. Sharp. Dr. Sharp, actually, just as an aside, this is an interesting thing. He was the son of an Episcopal minister, interestingly, given the other inhabitants of this building. And his father did work with, they didn't call them the homeless then, but he did work with the homeless. And Dr. Sharp didn't have a lot of money, so he went to Harvard on a rowing scholarship. He got there, he didn't do too well with the rowing, and so he started a business teaching not so smart but very wealthy young men how to pass their entrance exams to get into Harvard. So it was like sort of an early, the college prep classes, basically SAT classes. By the time that he graduated from Harvard, he had $100,000 in the bank. This is at the turn of the century. So it's just interesting to me. Anyway, he thought rather highly of his own talents, and he wrote a book self-referring as brain surgeon. But as I say, with Mr. Hurst's assistance, he bought all this land, he built this house, and he hired Mr. Hurst and his wife, Gertrude, who was well-educated, she was a teacher, to become the full-time caretakers of the land and provide food when he had company. And this relationship really developed. I understand that Mr. Hurst and Dr. Sharp also went carousing some from time to time, which may explain the reason that when Dr. Sharp and his wife decided that they wanted to give all of this property to the Hursts, that Mrs. Hurst didn't want it for herself. She wanted it to be used for the benefit of African American teachers. At that time, the schools were segregated, the beaches were segregated, and she wanted it to be a haven for African American children and for particularly African American teachers. So they wrote a deed wherein, and this is the critical document of this case, there it shows you just how beautiful it was back then. They had just these little outbuildings on the outer islands. And this is where, on the main property, Mr. Hurst kept alive a Packard that apparently was a mechanical wonder because no one could work on those cars at this point in time. It was by the 50s, but he managed to keep it running. So Dr. Sharp would get on a train in New York and take it down to Wilson, and Mr. Hurst would drive up in the Packard to Wilson and pick him up and take him down here to go hunting and walk the beach and so forth. And poor Mrs. Hurst would cook all the food on the mainland and then haul it across in a boat 3 times a day to Dr. Sharp and his family and friends. So the document that I referred to, the deed transfer, included these provisions. You saw the fish that they caught. Those were the days. The deed transfer was interesting because it gave the land to be used for the benefit of African American children, for educational and entertainment purposes for African American teachers. It also contained a provision that if at any point that land wasn't being used for those purposes, it would be offered to the state. If the state, for some reason, didn't want the land, then it would revert to the Hearst heirs. So after the schools after desegregation, the beach became less and less popular. And there were some camps that were set up there. These are just family members of the Hearsts. There were camps that were set up at the location, but over the years, they fell into disrepair. There was a trustee corporation called the Hammocks Beach Corporation that was supposed to be overseeing the camps. There was one that was rented for a while by the 4-H, one was by the Future Farmers of America. And by 2004, if not earlier, nobody was using this land. It was this gorgeous, gorgeous spot. And the Hearst heirs and some of Dr. Sharp's heirs as well went to court. This is actually in the late 80s. They went to court and had the land divided up some. And there was a settlement, basically, that each of them got to use part of the land. But in the early 2000s, Harriet Hearst Turner came to Charles Francis and said that land is not being used as the deed requires and hasn't been for some time, and I believe it needs to revert back to the family. So Charles took the case and over the next almost 9 years, argued the case to the state Supreme Court. He took it to the Court of Appeals twice. They had a jury trial. And at every juncture, he prevailed at the highest courts because it became clear over time that it wasn't just a matter of the language of the deed. It was a matter that the state, which had been offered the land on 2 different occasions and turned it down, was trying to step in and take this land with not even unjust compensation, but 0 compensation. They wanted to just take the land and use it as part of the state park down there or do whatever they wished. And it was a bruising legal battle. It was, Mr. Francis wanted me to make sure to mention that the Carolina Journal played a very important role in terms of the way the courts took a look at this case. Because for a while, it really was viewed as just these very complicated legal, mincing and dicing. And Don Carrington's story, that first story in particular, really refocused the energy and attention on the fact that this was a land grab by the state. And this is really a story about core property rights. Justice Newby wrote one of the important decisions in this matter, but it was in the end, on all sides of the political spectrum, actually, Mr. Francis was very successful. So finally, the state, and Mr. Francis has a lot of the legal documents in here. I know those are about as exciting as wallpaper, but in the end, what Charles was able to do was arrange a deal where the state purchased the land. Now, the state got a great deal for this land. It was 290 acres, about 290 acres, of unbelievably beautiful coastal property, pristine, for $10 million. The conservation fund stepped in and paid about a third of that money as a loan to the state because the state hadn't anticipated this cost. And the state stepped in with $6.9 million, and obviously our clients, John Hurst and Harriet Hurst Turner, prevailed. I mean, they got a very large reward. Harriet, interestingly, also negotiated a deal where 27 acres of the state land will be used, so long as she gets it set up within 3 years, will be used as a place for the original purposes that her grandmother sought for the land, for the educational and entertainment of young people, particularly young people in need. And John Hurst, I thought, is he's a remarkable, just a mountain of a man, very quiet. He was working as, he basically mans the dump in Onslow County. And he said he was going to keep working there because he's pretty close to retirement age and he wants his pension. But he worked on the weekends at a laundromat. And he said the weekend before this whole deal closed and everything was signed, he was working on a Sunday, and somebody came in and didn't understand that he was on this lawsuit as well, and told him to congratulate his sister. And he said to me, "Well, I reckon I might stop working at the laundromat now." Because he said, "I did some figuring, I think I could buy the laundromat." I think he could buy several, actually. So they both are working on trying to get this camp set up, and it was a remarkable ending to a very, very long battle. It took, in addition to all the legal battles, it also took going to the Council of State, which was also where I think the Carolina Journal had some significant input, because the Republican members of the Council of State, and you know, I'm married to a former Democratic member of the Council of State, so, but the Republican members of the Council of State quickly understood that this was an issue of property rights, and some of the other members were not so easy to sway on that. They didn't see it initially, and that's part of the reason that it took so much legal battling. But finally, they agreed. They agreed to the settlement, and that's where things ended up. Donna and I had also talked about the fact that I know you all must be very, very interested in the MAP Act. I'm sure you've had other folks come and talk about the MAP Act. The fact that the MAP Act was overturned, I mean, it's long overdue. It's such an the fact that that was on the books for so long is sort of astonishing. So we're hopeful that, as Donna said, that people are becoming more alert to what the government can do in terms of reaching in to your property, and not just taking it in its entirety, but also as the MAP Act allowed, allowing the government to basically put dibs on your land and hold it, inverse condemnation. But what we're seeing too, we have some cases involving the Atlantic Pipeline in eastern North Carolina. And it's interesting because, of course, John and Harriet, Harriet happens to be a paralegal, but there are a lot of people whose land is affected by some of the takings who are not always the most, it's hard for me to imagine, but some people don't actually know attorneys, and maybe they're lucky. But the pipeline, the Atlantic Coast Pipeline is comes through Virginia and West Virginia, down through North Carolina, and ends in Robeson County. And what we're seeing is so many clients who they're being approached by the companies before there's any approval from the Federal Energy Regulatory Commission. And so the company, it's Dominion Power and Duke Energy and the utilities, it's a natural gas pipeline. The companies are making their approaches to the property owners very, very early in the process and making offers that are very, very low. And their argument, of course, is that unlike a taking such as the state attempted here, that they're just seeking an easement. So, according to them, they come on your property and they take this easement and they give you the money and then they pretty up your land. If you go to the website, they have elk roaming on green lands. I hadn't seen a lot of elk in Robeson County, but what they don't mention is that, or they don't emphasize at least, is that the easements in a case like a pipeline, it's an easement in perpetuity. It's forever. So it's not just land that I would have, it's land that my children would have, and my grandchildren, and that easement you continue to pay property taxes on. And of course, 15, 20 years is usually, 15 years is usually when pipelines of this sort start to have problems. They have leaks, there are explosions. And so also in what we've noticed in the fine print of some of the offers is that the power companies are also able to transfer the easement. So in the future, they could transfer, conceivably, this pipeline right, this easement right, to a company that would transport petrochemicals or some other type of gas product, not natural gas. So it's an alarming thing to see in the documents. Now the pipeline to me is alarming because this is the old reporter in me, but I want to see a lot of the documents. But so they're taking this property right from property owners, but they're a private company. They're taking for a public right, but it's a private company. So we don't have access to the documents. At least when the DOT comes and wants to build a road, they have to show you. You can go online and see the documents, and you can tell, even part of the state's process is they're going to make a lowball offer, and they have, it's part of their calculation. If you look really carefully at the documents, they know that some people are going to get representation, or some people are going to push back, and they're going to get more money. But some people won't. Some people will be like, wow, I just put in a new HVAC. I could use whatever amount they're offering, and I'll take it. It sounds pretty good. Sounds fair. They always send really nice people to make the offers. So it's alarming to us to see that, but I do think the fact that people are becoming more and more alert to challenges to their property rights really holds potential for people to do better about protecting those rights. So I'd love to have any questions that you all have.
I'll take the first one.
Okay.
On the Hammocks Beach case, what was the state's justification for thinking that having been offered that property twice and turning it down, that suddenly they should be able to just take it with zero compensation? Seems inherently unfair.
Right. Well, it does. That's totally our position. So it turned on this early settlement of the property from the 1980s, where the state had said it wasn't a party to it didn't have anything to do with this land because it was originally one of the defendants in this early case. It said it had no property rights to this land. And so Mr. Francis used that as a judicial admission to say, you've said in court by your own pleadings that this is not your property. The legal grounding for that, I guess that they were trying to say that the deed, they went back to the deed transfer and said, it's supposed to be offered to us. And honestly, it was the decision of of a trial court judge, Judge Fox. He decided that the state should have another bite at the apple. And so Charles took it to the Court of Appeals. The Court of Appeals, Judge Wanda Bryant, Doug McCullough, and I think it's then Chief Judge Martin, ruled unanimously that that was incorrect, that the state had relinquished its rights. It had actually said it didn't have any rights to that land. It had turned it down already. So it's interesting. Yes?
As I understand it, the land that the Hearst will pay for was less than the total that was originally purchased. The final land was 200-something acres, you said, I believe, and then the original was more than that. So did all of the land not get deeded to the Hearst? Was there some land that the family, the original owners, kept?
There was some family land that had been carved out long ago, where they all have, each of the heirs has a home. John doesn't, but he's building one now. So that might be the difference there, yeah. And then the 27 acres that Harriet made sure were set aside for this camp. Barry.
You mentioned that a couple of the members, the Republican members on the Council of State, were persuaded pretty early. How did y'all go about persuading the other members, or at least the majority, as you said?
Well, I think part of it was the role of the Carolina Journal. I really do think that had a significant impact. And then Charles said that the attorneys who were members of the Council of State were finally won over. He asked Michael Weisel, was also, he had brought Michael Weisel in to kind of help too, and they had worked really hard to just set out the legal arguments as well as that core property rights argument. Yes, sir.
My question is broader, and something we talked about here a lot is the notion is what constitutes just compensation. It does go to your last, I think, point with regards to it. And I believe, correct me if I'm wrong, but very often the market value,
Right.
Which we have argued is by definition not just compensation, because if they wanted to sell their property at market value, they could. I mean, that's the definition of market value. So that means they actually value it more than market value. They don't value it at market value. They value it more than market value. And then we've argued that you should use sort of tort standard of making the person whole.
I agree.
That's why I wanted to get your opinion on it.
Yeah, no, I totally understand where you're going with that, because you're right. I mean, so especially, this is one thing I really love about North Carolina, that there's so many, like one of my clients, some of this land, she's got 2 different pieces of land that are impacted, big tracts of land. And one of them has come down for ages from her mother's family, and one came from her father's family. I mean, she's got a lot of history and connection to that land. And so if she had wanted to sell it, as you say, she could have done. Some of the land is close to I-95, and you know how that works with I-95, especially in that corridor. Some areas are not worth a ton, but in another 10 years, one interchange becomes, they get a Sheets or something, and suddenly it becomes very valuable. And so that's what, it's a very, very tricky thing. But those, pardon me? Yeah. Right. Yeah, so that is, and similarly, it's like the whole thing with this easement. If you have an easement in perpetuity cut across the middle of your valuable, 50-year-old pines, then it's just a question, is just being paid a sum for the use of that land enough when it's going to last forever? You know what I mean? To me, the fact of that easement impacts the value of the entire piece of land. So, yes, sir?
Could you speak a little about the London? Because that decision, I think it made legislators around the country come to the mindset that what is yours is now ours.
Mm-hmm.
And they just needed to come up with an argument to make it theirs.
Yeah, well, so you all, I guess, know what the details of the Kelo case are, but the idea that the government can come in and take a middle-class home as part of a urban revitalization project is sort of astonishing. I don't know that it's ever actually happened in North Carolina. Anything of that, obviously nothing that brazen, but perhaps you guys know of something that's similar. I mean, here I think they've hewed pretty closely on the true public use doctrine, but it is alarming. So I don't know where things stand in terms of the legislature moving forward with that here. Barry, do you?
Yeah, they've never passed a constitutional amendment. Each chamber has passed it, but they've never agreed to it.
They've never gotten together on it. Yeah.
And plus, the constitutional amendment doesn't specifically say, the proposed constitutional amendment doesn't specifically say that it can't be taken, for a private benefit. It just says, public use. I mean, it's really no different than the U.S.
The current language. Yeah. I don't know.
Ruth, I have another question for you. You made mention of it when you first took the podium, and I think your family members, maybe your kids said, do they realize, who you are there? It's no secret, of course, when you wrote for the News and Observer that your ideas and your views tended to be progressive. So when you went to law school and then started working as an attorney, what was it that really made you kind of say, wait a second, this isn't fair, what's happening here?
Mm-hmm.
Because those of us who are right of center, property rights is really core to the things that we believe, and so we're trying to figure out how do we convince more people to open their eyes and say, hey, wait a second, we all need to be concerned about this. This is an issue of such unfairness to people who get trapped by these things, like
Right.
the MAP Act or like this situation.
Right. So I actually think this particular issue is the reason Mr. Francis eventually hired me, because he and I met for coffee. I was just graduating from law school, and we were talking about, I said that I was really interested in eminent domain cases, in part because I think that it is, like I said at the beginning, I think it's one of those issues that unites people. I mean, it doesn't have a partisan, I just don't think it's partisan. If it's your land and somebody's taking it, you know you should be appropriately compensated, or it shouldn't happen, one or the other. But it's also interesting, just as far as the legal business goes, you can have, so we do a lot of, our firm represents some institutional clients like St. Augustine's University and the Raleigh Housing Authority and North Carolina Mutual Insurance and such. And then because those clients kind of keep the lights on, we are really able to be aggressive on our plaintiffs' cases. So we have some really good personal injury cases, for instance. You can have Mother Teresa injured in a car wreck and put her in front of a jury in Wake County, and the jurors are going to go, what's she coming after? Like, they're going to think she's doing something. But if the government comes and takes your land, the presumption of the jurors is going to be, how is the government trying to screw that person? I mean, I think it's just it's a core, people understand that the government is going to or the private company certainly is going to try to do it on the cheap. They're going to try to, and you're the one that's going to have to pay. So I just think it's like a different presumption. And so Charles and I talked about that, and I think it moved very closely with his understanding of the way things worked with the Hammocks Beach case.
I'll be the devil's advocate. I'm afraid at one stage we'll reach the point where you can't do anything. You can't build a new road. Look what happened in the pipeline. That you can't get anything done because I'm not giving it up unless you pay me $100 million, and then you can't do it because it's too expensive. So there is a limit to this somewhere.
Oh yeah, well, but the limit is in the court system for sure, because if you can't resolve it beforehand, then you go to court and a judge will decide. You know what I mean? There's a discrete end to all of it.
Reaching that point in many cases now where you just can't get anything done.
I hadn't seen that.
No, I'm not saying that you shouldn't have right, but there's got to be a balance somewhere.
Yeah, well, I think the legal system really does contemplate that, and I think it provides that balance. I mean, it does finally. You and I can just believe that the property should be, property should be valued under a more of a tort kind of a pardon me? Standard, thank you. I was lost. But the court is going to just do, they're going to use the appropriate appraisers and the appropriate experts and non-experts that will help them reach a determination of value, and a jury will make a decision. So it's not, there is a discrete end to it, really. Yes, sir.
Article 4 of the Constitution that gives us the right to have just compensation.
Yes.
Yeah, so it goes to the Constitution. It's not just somebody saying, I don't want to think to my land. You've got to have a good reason to put it there. You don't do it.
Yes, sir.
Ruth, I deal in commercial real estate, and occasionally we have these kind of situations to where neither party will agree to anything. Usually what happens is that the buyer hires an appraiser. The seller hires another appraiser.
Mm-hmm.
And they then take and come up with their numbers, and if the appraisers are within 10%, they usually split the difference and proceed. If they don't agree and they're not within 10%, they take and the two appraisers hire a appraisal firm
and that they both agreed to accept this independent appraisal.
That's got to be a little terrifying.
Yes.
So how has that worked in the cases that you've been a part of? I mean, have they in the end, split the baby, or have they?
Well, they're usually so tired of fighting that they are, let's go on.
Uh-huh. Huh. That's interesting.
Okay, one final question or comment?
Yes, sir.
The cases that you've been discussing, the pipeline as well as the beach project, am I right or wrong? Neither of them involves the state's quick take provisions.
Right. No, they were not. These are
Neither
not.
of them
No. Neither of them would qualify under the statute.
So for an individual who is in the path of a quick take situation, how do you proceed as the property owner that's right in the way of the freight train? What's can be done?
Well, there you got to get an attorney.
As far as strategy goes, is there a shadow of a hope that you can influence a more, what you believe would be a more fair settlement in that situation?
Well, I think that yes. I mean, the short answer is yes. You can definitely. I think that there's the opportunity for a better settlement, but those cases are so tricky because so under the quick take, under the statute, that's just a different. I haven't actually handled one of those, and so I don't know what the fine points of the strategy are. But it seems like those are, like you say, it is like a truck coming at you. I don't know. I'm not actually sure what you can do. Yeah.
Ruth Sheehan.